This is the second of a series of updates on recent developments in evidence, procedure and the substantive law, which are likely to be of interest to practitioners specialising in white-collar crime. The topic under consideration is the UK's new extra-territorial offences of corporate failure to prevent the facilitation of tax evasion under the Criminal Finances Act of 2017. And in an earlier video I looked at the political and the consultative background to the statute and why it's likely to be of interest not just to corporates and their lawyers in the UK, but also to the international business community and their professional advisors. I'm going to come now on to the provisions of the Act itself. It's worth starting, I think, with the long title of the statute. It is, according to its long title, an Act to, amongst other things, create corporate offences for cases where a person associated with a body corporate or a partnership facilitates the commission by another person of a tax evasion offence. The aim of the statute is pretty transparent. It is in reality to transfer a self-regulating role onto the private sector, including the burden and the cost of self-regulation, on pain of criminal sanctions, with corporations and partnerships being at risk of criminal liability and criminal penalties, really swinging financial penalties if a corporation or a partnership is convicted of one of these offences, if they fail to regulate and police themselves. That's the aim of the statute in reality. The scheme of the statute, the means by which it seeks to attain that aim, is essentially that where certain circumstances exist, and I'll come on in a moment to the circumstances that have to be shown for these provisions to come into play, but where those circumstances exist, the statute creates corporate criminal offences of strict liability, subject only to a statutory defence of having put in place so-called reasonable prevention procedures. But in relation to that statutory defence, the burden of proof is on the corporation or the partnership. So it's strict liability with a reverse burden in relation to the only available statutory defence. And it's probably important to note at this stage that the particular circumstances in which the provisions come into play, and that reverse burden is triggered, differ slightly depending on whether one is concerned with the evasion of UK taxes or the evasion of the taxes of another jurisdiction. There's a dichotomy in the 2017 Act between effectively offences relating on the one hand to the facilitation of the evasion of UK taxes and on the other hand to the facilitation of the evasion of taxes in other jurisdictions. And I'll come on a little later to the precise differences between the two. Let me start though with the offence in relation to the facilitation of the evasion of UK taxes. The section concerned is section 45 of the Criminal Finances Act of 2017, which creates the corporate criminal offence of failure to prevent the facilitation of tax evasion in relation to United Kingdom taxes. And it brings into play three key concepts, because the offence is committed by a, quotes, relevant body, where a, quotes, associated person commits a, quotes, tax facilitation offence. So there are three key concepts: relevant body, associated person, and tax facilitation offence. Let me just address each of those in turn. What is a relevant body for the purpose of this part of the Criminal Finances Act of 2017? In other words, what manner of organisation is potentially capable of being caught by these criminal provisions? And the answer is it has to be a corporation or a partnership, but subject to that, it can be a corporation or partnership virtually anywhere in the world. A relevant body which can be caught by these provisions is defined in the Act as being a body corporate or a partnership wherever incorporated or formed, and that means wherever in the world incorporated or formed. So that's one early indication of the extreme, if you like, extra-territorial effect of these provisions. What about the second concept, an associated person? Well, the wording of the provisions makes clear that what is caught by that phrase is an employee, an agent, or any other person performing services for or on behalf of the corporation or partnership. That's an associated person. So when one is looking to see whether an associated person, an individual associated with the corporation or partnership, has facilitated tax evasion, that is the very wide definition of who is an associated person for these purposes. And then the third concept, tax facilitation offence. Well, this is probably the only piece of reasonably good news in these provisions from the point of view of those working in the business sector and those advising the business sector. It's not all bad news, because the effect of the provisions is that before a corporation or partnership can begin to be at risk of criminal liability, at least two individuals first have to be shown to have committed a criminal offence. There must be a taxpayer who can be shown to have committed a tax evasion offence. They don't need to have been convicted of an offence, but the prosecution have to prove that a taxpayer has in fact committed a tax evasion offence. And the second person who needs to be shown to have committed an offence is the facilitator, the associated person who is shown to have facilitated the evasion of tax by a third party. And it's crystal clear that what the legislation has in mind is an individual within a corporation or partnership providing either financial or professional services to the taxpayer. Now, that individual, that person associated with the company or partnership providing financial or professional services, must be shown on evidence to have engaged in conduct giving rise to what's called secondary criminal liability under United Kingdom law. And that means, effectively, aiding, abetting, counselling or procuring the commission of the primary tax evasion offence. So that's the definition of tax facilitation offence, and I suspect the question that most often asked by people looking at these provisions for the first time is, what does tax facilitation offence really mean in concrete terms? What does the taxpayer need to have done? What does the so-called facilitator need to have done? And for the purposes of today's discussion, it's probably sufficient to refer to the government's own guidance on this legislation, which makes absolutely clear that the associated person, the so-called facilitator, must have acted deliberately and dishonestly to facilitate the third-party taxpayer's evasion. Unwitting facilitation of tax evasion through accident or through ignorance or through negligence is not capable of giving rise to one of the new corporate facilitation offences on the part of the corporation or partnership with whom or with which the facilitator is said to be associated. Now, if those circumstances are made out, so if those three boxes are ticked, we are then in the territory of strict liability, subject to the reverse burden of proof. The corporate or partnership will be guilty of a criminal offence unless it can establish a statutory defence in relation to which the burden of proof is on the corporation or partnership. However, even where a corporate fails to prevent the facilitation of tax evasion, it will have a statutory defence where it can establish on the balance of probabilities either A, that it had in place so-called reasonable prevention procedures to prevent persons associated with it facilitating tax evasion offences by third parties, or alternatively the second limb of the statutory defence, if it can demonstrate that it was not reasonable in all the circumstances to expect it to have any prevention procedures in place. And I will come on in my next video to consider what is meant by reasonable prevention procedures.